appending arrest allegation based. 198.
5/2/2015.
Mallet.
So it is anticipatory bail. No,
Unsuitable.
regular bail.
Unsuitable.
No, BLAPL number 19912 of 2014.
14.
It says BLAPL
Order
number,
time.
not anticipatory bail.
Order they have. They are not given there.
This is in between, just see, page 3. After lodging the FIR, the opposite party number 2 apprehended arrest and before this on court by way of filing petition on 438 into which was registered in the BLAPL. On those days, BLAPL kind of. Petitioner is assailing the order dated 5/2/2015 passed by this court in BLAPL number 19912 of 2014, whereby the opposite party number 2 has been given the concession of pre-arrest bail. The matter is pending since 2015. 9 years have elapsed by now. None appears for the petitioner. Therefore, I am not inclined to entertain this petition. Accordingly, the same is dismissed. Yes.
I may be taken up next week, my lord.
I your lordship, the matter has been already in
They have not filed the requisite.
in process, your lordship. The
Mr. Mist.
main GR case has been already quashed, your lordship,
Acha.
on 18th March 2023.
In this matter,
There
Mr.
is a
Tripathi has
no-
gone to Coimbatore for a meditation.
Anyway, but you have not filed process also by the time.
Well, I am
when
unable to
counsel
take
for
the
party
instructions.
submits.
Planet.
You are appearing for opposite party.
Respondent number 1, 2, 3, 2, 3, 4.
Then counsel for opposite party number 2 to 4 submits that in the meantime, the here case out of which the present proceeding is arising out
And
of
all
has
the
already
cases
been
also dropped.
already been quashed. So therefore, the petition, the present petition is rendered in
18th March.
in view of thereof, the petition is dismissed again.
Obliged.
I detail for Sierra Leone 2021. Thereafter.
Disposal.
High level.
And here notice could not be sent to opposite party number 2 due to non-filing of requisites.
Requisites.
My
whatever
learned-
2011, 21, you are not filing requisites.
No, last week it has been issued. Notice was
Ah.
issued last week.
Last week after 21,
Yes, my lord.
after 3 years.
day after yesterday,
Anyway, it is in practice what?
my day after yesterday, my London senior Mr. Tripathi has sent to the WhatsApp only that order and cause title. We have received my
It's all right.
high
Ah.
level.
6.
May I
Yes, sir.
tell you also? In this case, I have challenged the order issued by KC Chari 2024. Bail has been allowed by the second edition.
Bail allowed?
By the second edition, Cuttack, on 27/4. After that, when he has been released on bail, myself is a girl child and he has threatened me to kill me on the road. So many times he has given the threats. So on the Chari points, I have filed another FIR before the Cantonment police station. My honorable submission before you go for the cancellation of bail bond, which I am allowed by law.
Now, what was the offense?
Offense at 376(1)(d). FIR is on file against the phase 2 police station, and he has been released on bail, concerned Abhishek Naik accused. And after that, when he has been released, he is trying to kill me on the road. So many times he has given the threats to me also. Again, I filed
Petition 2, my lord, has been filed.
4th evening.
He shall not certain influence the informant, victim.
Condition number
2.
annex
Page 21. my lord.
21.
Annex 2.
Yes.
1 and 2 both. He shall not commit any offense in future. He shall not threaten or influence informant, victim.
So Annex 3, again, he has given a threats to me on the roads of Balyatra Fields and also.
Where is that?
I filed Annex 3, page 22,
Subsequent part.
after the release of from the custody. That has been registered on 4th May 24.
4th May.
Yes. Annex 3,
When the
page,
bail was granted?
bail was granted
27th
on
April.
27 April.
What have you said in this?
He is trying to threaten me on the road. He has given so many threats also. I will kill you if you not withdraw the case filed by me. So in this case, he is threatening you again and again.
Yes,
Issue notice
issue notice,
to OP2, my lord.
OP2. Returnable within 1 week. Yes.
Okay.
Pray, my lord, modification of order dated 16/5/2024, my lord.
Sorry?
Modification, my lord. The petitioner shall surrender to jurisdiction of the competent court by 30/6/2024 and avail remedy under the law.
What do you want to say?
My lord, the petitioner may be directed to surrender and release on bail before the learned
Nay,
GMFC.
what is this matter is about? Justly pleased to quash the order dated 26/4/2024.
Madam.
DR case number passed by JMFC also. What is that 26/4/2024? Which order is this?
Page 9. NBW, my lord.
NBW.
My lord. But they, in the meantime, I'll transport to other court.
No.
Huh?
Surrender and release on bail, my lord.
Could not surrender before the JMFC losing a within
Hey,
stipulated period. That's why he.
Avail remedy under the law. Surrender କରି ପାରିବେ।
But this is, what is this? A criminal MC. How it has come to me?
Earlier you have disposed of
Earlier
they have
dispose-
filed IA, my lord, for modification.
For modification.
This. Achha, modification.
Modification.
Modification of what modification? Which, where is that order which I passed?
My lord,
Page 9.
page 9.
In IA.
IA.
Yes.
Good account, modification correct.
What modification you want?
My lord, direct to the petitioner to surrender and release on bail, my lord. The last para 3, page 10, my lord, the petitioner shall surrender to jurisdiction of the competent court by 30/6/2024 and avail remedy under law. 307 is there, my lord.
For that reason, stay करके से कल surrender करेगा किसी भूल करेगा. Your
What
NBW
is wrong?
stay and this one will be directed to avail the remedy and state the NBW till 30/6/2024.
That is,
You have to surrender there.
if you want extension time, I will give extension of time. That's all.
It is not here.
My lord.
Right, let us counsel for the petitioner.
Yes, sir.
In the IA number 16/4 of 2024. 6 modification of the order. I'm not inclined to entertain this application. However, the time granted to the petitioner to surrender before the court is extended up till 15th of July 2024. 24. Petitioner is directed to surrender oblique appear before the court below on or before 15 July 2024 and seek appropriate remedy available to him under law. With this observation, the application.
Charge sheet, since charge sheet submitted showing not arrested, for that is lordship pass usual order.
I have extended the time. Yes. Yes, sir.
My lord, on behalf of Mr. Kumar Kara, he is ill to the matter में काल भी आते हैं. Next. Due to illness of Mr. Kara.
What is
Sir,
this?
appeal matter, my lord, against conviction.
Conviction.
Section 7 trap matter. May be taken in the weekly list chronologically.
Weekly. Yes. Yes.
Item 9.
My lord, this is for
May I
perhaps.
please, Milos, this is also a trap case, Milos, under section 7 and 13(1), Milos. Milos, what I require is some time to get prepared, Milos. Paper book has been filed, Milos. Paper book was prepared and has been filed in the registry.
Lordship may kindly accept those paper books and direct the registry to serve a copy.
2009 it is pending.
Ma'am.
Milos,
Paper book is ready.
Yes,
paper
my
book
lord.
has been ready, has been filed
The
also.
noting has come, my lord, for
Paper book-
lordship's kind
paper book
acceptance.
has been already been filed. You got the copy?
No, my lord. It is there for acceptance.
okay.
If your lordship will accept, then
It
only
will
the
be accepted.
my lord.
The registry is directed to supply a copy of the paper book to Mr. Rijvi. Leaves the matter for final disposal on.
Weekly, it will be
Weekly,
tagged, my
weekly.
lords.
Yes.
And then
10 also, my lord, it is ready for hearing. Last time the learned counsel for the appellant was present.
Hmm.
I'd say where, maybe
Right.
taken up in the weekly.
Paperwork, everything is ready.
Yes, my lord, it may be taken up for hearing under the weekly list.
Hearing.
Weekly. rep.
And 12. Revision.
What happened? 11?
Your lordship,
Huh?
I think
11,
11.
11 has been adjourned, my lord. It was mentioned. Your lordship was pleased to adjourn it and to tag up in the weekly list.
But we were not informed. We are for the appellant
It's
number.
all right now. Number 11.
Third, 11.
The problem is somebody has mentioned behind you. What to do?
In
That's
fact,
the
we had in one of the.
But I have not adjourned it. I have kept it in the weekly list. Get ready so that we can
Weekly list,
proceed
no.
with the matter.
Next week.
Yes.
It is there. You come and mention, get ready and I'll finish it up.
Yes.
This is against discharge.
No, this is conviction.
Conviction,
Conviction.
appeal matter.
3 matters we can hear.
Yes, together it can be.
That is the reason why it got stuck, because I had already argued my appeal, one of the accused.
Yes.
And the state was to
The
respond.
evidence is same.
Evidence is the same,
Then we can analyze.
but the other appellants went on taking time.
Issue थोड़ा सा top रख दी. 3 matters can be
Disposed of together. Weekly
Yeah.
matters.
Weekly list. Get ready for next week anytime.
I am ready.
At 2 o'clock, you tell me so that in morning you send your junior. Mention it. At 2 o'clock, I'll fix so that everybody will come and. Okay.
Tuesday at 2 o'clock you will have.
Yes.
Tuesday, I think 1 matter or 2 matter is there.
Yes, my lord. Tuesday can be. It can be on Thursday also. My lord. It's 4th.
4th matter is there. Huh? 4th 2 o'clock.
4th we can do it, my lord.
Indicate.
4th 2 p.m.
Huh? No, in the weekly list you indicate.
This matter will be taken up at 2
Take
p.m.
it up
on,
at 2 o'clock
at, on 4th of
Indicate.
July. Yes.
Yes.
Item 12.
Yes, sir. Non-APS last time. Last what is the non-APS? Registry is directed to inform the land council for the petitioner regarding the listing of the present case. List the matter tomorrow.
13.
1 minute. Pass it over. Because last time registry was directed to intimate the council for the petition. Has the registry done it? Inform. Mr. Huh? Pass it to Ranachi. Otherwise, this is against conviction of what?
13.
Yes. This is the what?
Consolidated petition is not yet filed.
No. What is he is seeking quashing of the entire proceeding? What under which provision he is? 482. How it is listed? How it is listed? He has filed a 482 petition. And how it is now? Huh?
Not this, my lord.
13.
This 13.
14, my lord.
1 minute, 1 minute. 13, initially he has filed, this is a petition under 482 CRPC for quashing up the entire proceeding. I don't know, nobody appears, none appears. I don't, this is a petition, in the present petition, petitioner has invoked the jurisdiction of this court under section 482 CRPC, inter alia seeking following relief. Prayer utar de, prayer utar. Subsequently, the petition has been numbered as a criminal revision petition. Initially, it was initially the petition was registered as CRLMC number 1549 up to 2012. However, subsequently the said petition is converted to revision, CR revision 802 up to 2012 by order dated by the court order dated 13 12 2000 13 12 2012. Thereafter, none appeared for the petitioner, and the defects pointed out by the registry has also not been filed, and consolidated petition has also not been filed. Since the matter is pending since 2012, it seems the petitioner is not interested to proceed with the matter. Accordingly, the petition is dismissed. Yes, madam.
Item 14, my lord, not this.
Not present. Yes.
15.
Last occasion, your lordship directed to remove the defect within 1 week.
This matter is pending. What is this matter is about?
Sentence of 324, 426, 447.
Conviction.
Yes. Mr. Raghuda office.
In 2013, this is pending. Defects are not cured. No,
His
none
office.
appears.
Mr. Raghuda's office.
Are you really interested or not? See, 2015, 13 it was filed. Defects not cured. 2015 is listed, none appeared.
It belongs to NK Das, my lord. He was my assistant.
And thereafter 15, again it none appeared.
My lord.
When the matter was taken up again on 2024, somebody asked time.
My lord. It belongs to my lord NK Das. The power is there.
Whether really interested or not.
I will inform him, my lord. Mr. Das, my lord NK Das.
In 2013, the accused was 44 years. Just pass it over, just check it up.
Date at 2 PM, my lord.
On the ground of incompetent petition, being the defect being not cured, it can be dismissed. Yes.
Item 16.
The QZ says not filed till date for issue of notice.
Just see the service position. Huh? 138. Item 16, na?
Item 16.
Hmm? 223. The present petition is arising out of a complaint under section 138 NI. The petition is pending since 2013. 13. The petition, notice was issued to the opposite party on 27/11/2013. When the matter was taken up on 4/3/2014, none appeared for the petitioner. Thereafter, none appeared for the petitioner on 11/3/2014, 21/3/2014, 31/3/2014, 14. However, on 7/11/2014, Mr. Bhuya appeared for the petitioner and appeared for the petitioner. On that day, none appeared for the opposite party. It seems the service on the opposite party is not sufficient. Therefore, on 18/12/2023, this court directed to take steps, directed the petitioner to take steps to serve for the opposite party. Since then, requisites has not yet been filed. Therefore, the service on opposite party is not effective. In that view of the matter, the petition done. Yes. Yes.
Item 17.
Substitution is not required.
Hmm?
Here also substitution application is not yet filed.
Sole
Disease.
disease died arising out of 138. This is pending since 116. Non-APS on your the petitioner. What's in the file called this time, but hmm? 14? None appear on behalf of the petitioner, peruse the service return notice limitation at the issued sole responsibility is written, answered, and endorsement to the addressee expired. Steps for substitution of an RFO, deceased sole responsibility has not been filed. Right off. The present matter is arising out of a complaint case under section 138 NI. The matter is pending since 2016. 2014. When the lastly when the matter was registered on 14/8/2019, the following order was passed. The petitioner has not taken any steps to comply the said order. None appears for the petitioner to do. In that view of the matter, the petitioner is dismissed. Yes. Item 18. They are not interested because
Legal.
sole accused in 138 died. 18, eh?
18 milots, I am there virtually.
Yes.
Milots, this is against an order of the authorized officer milots, rejecting a petition filed by me to permit the petitioners, the appellants milots, to trade in the shares which they had purchased, and after the trading is completed, to deposit that amount in the form of fixed deposits in the court. The facts are like this, milots. The appellants are facing a trial, milots, on allegation of being in possession of disproportionate assets.
Yes.
They had 2 demat accounts, milots, and they were purchasing and trading in shares, milots. Those have also been attached, milots. And on the date of attachment, milots, the value of the market value of the shares, milots, stood at 49,19,987. Now, meanwhile, milots, because of fluctuations in the market, some of the shares, they have become redundant, milots, because the companies have closed down. Some shares have lost much in value. Some shares are still being traded. Now, our prayer before that court was that we may be permitted to trade those shares, that is, sell those shares, and that amount which we derive from the sale, that is to be deposited in the court, milots. The court has rejected that on 2 grounds, milots. Number 1, the court says that an earlier petition had been filed, which had been rejected, and against that, milots, it was not assailed in the superior court. The second is that we will not deposit the amounts which we derive, milots. Now, my submission is that both these grounds are baseless, milots. Because, first, the question of res judicata doesn't apply in criminal proceedings, milots. The mere fact, milots, that I did not challenge an earlier order doesn't prevent me from making the same prayer once again, milots. And for whose benefit I am making this prayer? It is for mutual benefit of both, milots. Not that it's for my benefit. Then when they permit me to trade in the shares and I sell those shares, the money is not credited immediately, milots. And if the bank is directed not to disburse that money, but to make that money into a fixed deposit, milots, which I can deposit in the court, on which interest will bear, how can it be said, milots, that I am not going to deposit, milots?
If trading takes place, it will come to the
Yes, it will come to the account.
Ah.
It will come to the bank's knowledge, milots, and bank will be directed to make it into a fixed deposit. That's all.
My lord, in this case, they have prayed for a release of the share, my lordship, and the share proceeds to be deposited in the demat account.
Yes.
And my lordship, in this, so far as this
Otherwise, the value of the share goes.
Yes, my lordship, I am submitting. First thing is, so far as the release of the demand, that share is concerned, there is no provision under the Odisha Special Court Act to release the property. Only my lordship, there are and division bench decision.
My learned friend maybe is not audible, milots.
My lordship, one decision, my lordship, that is 2016 to OLR 1107. My lordship,
What does it say?
my lordship, that can be seen. That is, my lordship, one. Your lordships will see that the division bench of this honorable court, and I was also the arguing counsel in that case. My lordship can go to page 1112. 1112. 1112. Para, my lordship, the first paragraph, last line, thus. It starts from thus.
Thus, section 19.
Thus, it is, no, my lordship, page 1112.
Yes, 1112.
1112, last line. That last, that para, above that, my lordship. Thus, it is only the authorized officer. Got it, my lords?
Which paragraph you are?
Before that,
Yes, thus it is only the
thus
authorized.
it is only the authorized officer who can dealt with the property in the manner prescribed under the provision of the Act 2006. No doubt the authorized officer has jurisdiction to refund or return the money or the property or both involved in a confiscation proceeding under two contingencies, such as when the order of confiscation made under Section 15 is modified or annulled by the court in appeal under Section 17 of the Act 2006, and whether the person affected is acquitted by the special judge in the trial. This is the two contingencies, my lordship, where the seized property can be refunded. There is no, so my lordship, it is not coming within this, no fine. And my lordship, another decision I have given my lordships in a similar case of this honorable court, that is my lordship, CRL 692 of 2021. My lordship can see that order. I am reading out very small order. This matter is taken up through hybrid mode. Had learned counsel for the appellant and standing counsel of the Vigilance Department. The present appeal has been filed under Section 17 of the Odisha Special Courts Act. The appellant questions the correctness of order dated 1/9/2021 passed by the court below in CC number so and so, whereby this prayer for release of amount invested in shares with, this is also regarding the share, shares of Karvi Stock Broking Limited worth rupees so and so was rejected. The fact of the case briefly stated that the appellant is facing trial for the offence under Section 13(1)(e) of the Prevention of Corruption Act in TR case number so and so of the Special Court Vigilance Cuttack. Simultaneously, confiscation case number so and so has been initiated against him in respect of seized property in the court of authorized officer, Special Court Vigilance Cuttack. It is further seen that the document relating to investment of shares with aforementioned company and amount were recovered and seized. The appellant filed an application in the court below seeking release of amount invested in shares on the ground that the same is required for treatment of ailing wife. Learned counsel for the appellant has argued that the amount having been invested in the share market, which is volatile in nature, that if allowed to remain as it is, would be subjected to either deduction or enhancement of its value in due course. This would inure to the benefit of no one. He therefore submits that the amount should be released in his favor, being indemnified appropriately. And Mr. S. Das, Lone Senior Standing Counsel, on the other hand, submits that the confiscation proceeding is at fag end in as much as the last among the three witnesses cited by the prosecution is being examined. If the amount is directed to be released at this stage, it would seriously prejudice the prosecution. On the other hand, if the confiscation proceeding ends in favor of the appellant, he would be entitled to take back the entire amount along with the other properties. After considering the rival submission, particularly taking note of the fact that proceeding is at fag end, this court does not deem it proper.
What is this says?
My lordship, on 10th of July, my lordship, only IO will be examined. In that case, in this case, only IO's examination was going to be held.
Yes.
This is the only thing.
Yes. Now, my lords, can I submit?
My submission may be recorded,
Let
my
me
lords,
conclude.
that the IO's.
Yes. Yes.
My lords, now my submission, your lordship may take note. Two decisions my learned friend has cited. First is Renovada Das versus State of Odisha
Yes.
by the division bench, my lords. In Renovada Das, what was the question? The question was whether after the death of the deceased, my lords, accused, it was incumbent upon the whether the court could release in favor of the legal heirs. There the accused is dead. Now, what their lordship say is this, that it is the authorized officer who has the jurisdiction to refund or to return money or the property. Now, am I asking for
two contingency?
Yes. My submission is this. Am I asking for a refund? Am I asking for a return? The answer is no. I am only asking
But how will get over that double?
I am submitting. I am only asking for permission to allow me to trade. I sell those shares and I deposit that money in court. I am not asking it for myself.
But these shares has to be released to you.
No, they need not be released. My lords, my accounts have been frozen. If they allow lifting of freezing, my lords, the day they allow lifting of freezing, I sell whatever shares are available to be sold. The money which I get out of it, my lords, the bank will be directed to make it into
the account which has already been freezed has
Yes.
to be defreezed.
Yes.
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 My lords, that is subject to risk, market risk, my lordship, and so far as Domborudhana is
My
concerned.
learned friend
similar
doesn't
issue-
have the
similar issue-
patience to understand,
and
my lord.
Similar issue on 10th, my submission may be
No,
recorded.
suppose it is defreeze for 1 day.
Yes.
You can trade everything.
Yes, I can trade everything. I put everything for sale.
It can be defreeze for 1 day. And he trade all the
My lordship,
shares which he has.
Yes.
And that money will be coming to demat account. And
That
My
amount
lordship,
can be kept
my
in a
lordship,
fixed
all
deposit.
are subject to market risk, my lordship. And so far as the Domborudhana is concerned, case is concerned, my lordship, similar issue was taken up. My
Not
lordship,
at all. Not at
argued,
all similar.
And my lordship, this court, as it is in the fag end of the inquiry, and this case,
when the date is fixed?
10th of July, my lords.
Learned Council for the State Vigilance submits that the confiscation proceeding is the fake end, and the matter is fixed on 10th of this month for recording of evidence of IO.
That is the last witness.
The IO is the last witness. In view thereafter, the matter adjourn the matter to 20th of this month.
Yes.
20th of this month, and it is expected that the confiscation proceeding, the authorized officer would conclude the confiscation proceeding by next date of it. To conclude it.
With due respect, my lords.
Yes.
My lords, will my learned friend undertake that the IO's evidence will be concluded on the 10th?
I have given a
This will
direction
be-
that it should be
No,
done.
I am submitting. This will be the first case then where the IO's evidence is taken up and concluded on the same day. Because, my lords, the IO will place his entire evidence of investigation. He has to be cross-examined. And normally, my lords, it takes days, my lords. My learned friend is only trying to be fool and be fertile, your lords. He is only trying to misguide your lordship, my lords,
so
by
far as
giving such a
Then
statement.
he is a very competent lawyer. If he
No, your lordship may look at the impugned order which I have. My lords, with due respect, would your lordship look at the impugned order which I have filed? My lords, may kindly look at page 13 of the brief, my lord.
Yes.
I'm sorry, look at page 12 of the brief.
Yes.
My lords, may look at the fourth line from the bottom.
Yes.
The court writes, furthermore, there is nothing in the petition to substantiate that the market value of the shares are suffering from depreciation and loss.
That is
Then-
fluctuating always. Is not.
Yes, your lordship may see the next sentence. That apart, in this case, the IO will be examined shortly and evidence from the side of the prosecution will be closed. ये order टा केबे pass ହେଇଥିଲା ଆଜ୍ଞା? IO ଆଜି ପର୍ଯ୍ୟନ୍ତ ଆଜ୍ଞା
ବର୍ତ୍ତମାନ
ପରା
ତ ମୁଁ
examine
date ଟା
ହେଇନି।
କହୁଛି ନା, date ଟା
ଆଜି ପର୍ଯ୍ୟନ୍ତ
that
ଆଜ୍ଞା
will be
IO
recorded, my
examine
lordship, my
ହେଇନି।
son.
11/7/23 ରୁ now we are in June 2024 my lord. ଗୋଟେ
And-
ବର୍ଷ ପର୍ଯ୍ୟନ୍ତ ଆଜ୍ଞା ସେ IO କୁ ଆଣି
If it will be the submission of
ଖାଲି
the
ଗାଲୁ
Learned Council
ମାରୁଛନ୍ତି,
for the
my lord.
appeal and
My
my
learned
submission
friend
is
is
that in
only trying to
What
create.
he says is
Yes.
July 2023.
Yes.
This was the observation of the authorized officer.
My lordship,
Why have you not?
my lordship, in that page 12, my lordship, I am reading out the first paragraph
Okay.
in the middle portion. As regards the delay, my lordship got it? No, when that, as regards the delay, the experience of this court shows that delay is mainly caused due to non-cooperation by the opposite parties.
Yes,
And this case can be very well disposed of without delay if the opposite party cooperates. This is the conduct of the present appellant. in the
No,
court below.
I dispute what my learned friend is stating, my lords.
That is
I
the
would
order.
request
That is
your
the order.
lordship,
Findings what to do.
my lords,
that
I
is the
would
findings
request your
and,
lordship to kindly call for a report. Let a report be called for as to what delay has
No,
been caused by us.
let us not stress the matter.
No, my lords, let us stretch the matter. Because, my lords, justice is at the stake, my lords. Justice is at stake because of the erroneous submissions of my learned friend. It's a question of justice being at stake. My learned friend is misleading your lordship. He is misleading your lordship just as the authorized officer is writing. Let a report be called for as to what adjournments have been taken by us.
Mr. Devasis Pondar, let me counsel for the petitioner. However, submits that the examination of IO has not yet been done, despite the fact that the IO is summoned for examination way back in 11/7/2023. There is no explanation coming forth as to why the IO has not yet been examined since 1 year has left in between. Be that as it may, Mr. Das and Council submits that the matter is fixed on 10th of July for recording of evidence of IO. The authorized officer is directed to do well to see that the evidence of IO is recorded without adjourning the matter, and the confiscation proceeding shall also be concluded as expeditiously as possible. Leave the matter on 20th. 20th, I'll see whether IO has examined or not. Otherwise, I'll allow it.
And with a small prayer, my lord. My lord, one small prayer.
IO is not examined.
Yes.
On 20th, I am going to
Release the
defreeze the account for 1 day.
Yes.
He will trade the entire share.
Yes.
And whatever the rate may be on that day.
Yes, my lord.
And that money will come to demat account and freeze again.
Yes. Yes.
Lords, one small
You can't leave it to speculation of the market.
My lord, free copy of the
Lords,
order.
one small prayer.
Yes.
One small prayer. Your lordship also asked the authorized officer to submit before your lordship as to on which date the IO's evidence was adjourned on the prayer of the defense.
If he doesn't do that,
outright falsehood is being spoken, my lords. By the Vigilance Council, I am sorry to say he is making outright false submissions.
ମୁଁ ତ ସବୁ ରେକର୍ଡ ରୁ ପଢିଲି
କୋଉ ରେକର୍ଡରୁ ଆପଣ ପଢୁଛନ୍ତି?
ଆପଣ ଦେଖିଲେନି?
ମିଛ କଥା ଗୁଡାକ ଆଉଟ୍ରାଇଟ୍ ମିଛ। ଆଜ୍ଞା ମଗେଇ ଦିଅନ୍ତୁ ସେଟା ଆସୁ।
19th. It is 19th, not 20th. 19th.
Yes.
Yes.
Pardon to mention, my lord, item 16. I mean, given 3 days time to file the requisition. Item 16, my lord.
Oh, 16.
Yes, madam.
Huh?
Item 16.
I have already dismissed. You have to, because I have recorded so many things.
Once it was noticed, but he has not appeared thereafter.
Thereafter, it is pending since 2014.
2013, my lord.
In the 138 matter, how much the court will take?
He has not appeared. Once it was noticed,
and thereafter you have not complied. 2023 order is passed.
Yes,
you don't file requisites.
I may give in 3 days time. In the meantime,
16, huh?
Yes, madam.
See, this is how the matters are unnecessary, pending in this court. 2013 matter.
Yes, madam.
138 matter.
He has not appeared, madam.
I don't think he will appear also.
Madam, notice has gone. Notice was sufficient, but he has not appeared. Opposite has not appeared, madam.
Let him not appear. Forget it. How does it make a difference?
If he dismissed, then I will be really punished.
This is whole difficulty. Leniency doesn't mean that, this matter is taken up, you filed in 2013 and you have not appeared, not once. I have recorded everything.
Opposite party.
3/1/2014, you have not appeared. And 21/3/2014, you have not appeared. 11/3/2014, you have not appeared.
No, my lord.
And 31/3/2014, again you have not appeared.
No, opposite party not
And
appear. I'm for the petitioner only.
I know petitioner, non-APS for petitioner, non-APS for petitioner, non-APS for petitioner. And all of a sudden, 2023 comes and appears that I'll file requisite. And court gives you time, thereafter you don't file requisite for 1 year. How much the court can give you indulgence, you tell me? There is a limit to that everything. Otherwise, I never do all this dismissal and all. Non-appear for the petitioner, non-appears for petitioner. Just see the proceeding. Just so. If I am telling wrong, you just see. From 2014 to 2023, matter listed many times. You have not appeared. What is the check amount?
No, check amount 2,80,000.
How much you have paid?
Not the, there is business transaction. Around 17 lakhs, some odd. Out of 17 lakhs, I have already paid around 15 lakhs.
Now, what is the check amount?
Check amount 2,80,000.
See, after the amendment.
I have given a blank check. He has made the amount, but then thereafter.
But after the amendment in the NI Act, section 143 capital A and 148A, you after conviction you have to deposit 20%. That also you have not done. In this situation, I don't think he is interested also. Notice is not served. Move an application. Move an application, I'll do it. Move an application, I'll do it.
Item 19.
May I please, Lord, sir?
He may not be interested also.
All right.
Opposite party may not be interested. He might have forgotten you. Who knows? Okay. Yes.
May I please, Lord, sir? My lord, the petition.
Move the application if any problem is there. Move the application is recall. Okay. Yes.
My lord, the petitioner, the
Item
accused 19. Petitioner, the accused in the court below, convicted under section 138 NI Act. Appeal also confirmed. During revision, the dispute between the parties was settled. They have also payment he already
Very
made.
good.
They have filed
Yes,
the compromise affidavit.
Beyond compromise, you have filed.
Right. Compromise. What? I'll write record it.
Affidavit already filed. That is in
Fine.
record.
Where is that?
That is in the record.
Affidavit. Write down. The present matter is arising out of a complaint under section 138 NI. The petitioner was convicted by the court below. And the appeal filed by the petitioner is also turned down. Therefore, the revision has been preferred by the petitioner, challenging the judgment of conviction and order of sentence dated sentence
22nd
dated
December 2009.
22/12/2009. While the matter was pending before this court, the parties have settled the dispute and placed on record a joint compromise, placed on record an affidavit, a joint affidavit dated 11/3/2020. In view of the joint statement made by the parties in the affidavit dated 11/3/2024, the impugn order dated 22/12/2009 passed by
the London SDJM Panpos, Raulkela.
Panpos Raulkela is set aside on the ground of settlement. Accordingly, the petition is also disposed.
Appeal order time.
Appeal order. Which is the appeal order?
Appeal order is Annex 2, passed by London.
Right on.
Additional session judge
impugn order dated 27/11/2010, passed by
London Additional Session Judge Raulkela.
Additional Session Judge Raulkela in
Criminal appeal
number
9 of 2010.
9 of 2010 is set aside on the ground of settlement. Accordingly, the petition is also disposed of.
Okay.
21.
Yeah, 21.
This pertains to my lord, sir. This revision is directed against an orders framing charges. My lord. If lordship turn to page 89, my lords. 89, page 89, my lords, may we glance through, my lords.
80.
89, my lord, 89. The page indicates that charge under section 13(2), 13(1) D.
Annexure.
That is annexure 2, my lords. Annexure 3, my lords.
Yes.
Annexure 3 is at page 58. Your lordship turn to page 89. This is the relevant page indicating the essence of the orders.
Order dated.
Order dated 7/11/2012.
12.
Your my lord, the charge has been framed, my lords.
Hmm.
Now, in the absence of any interim orders, I believe it's no interim is
Right.
passed, my lords.
The
They
present
is need not
petition
to
is-
say that after the framing of charge, not the trial begins, my lords.
Right. The present petition, in the present petition, the order dated 7/11/2012 passed by
The Lord
the
says,
Special
Sub-Judge,
Vigilance
Special Judge
Bhavanapatna
Vigilant Bhavanipatna.
in GR case number 24 of 2006 is called in question. By the said order, the court below had framed the charges against the petitioner for offence under section 13(2). We read with section 13(1) C and D of PC Act, read with sections 409/468/477 capital A /120 capital B of IPC. In the absence of any stay order being granted by this court, the trial might have proceeded by now. The matter is pending since
2012.
2012. None appears for the petitioner. In that view of the matter, the petitioner-
Earlier also. Lord's previous order sheet also.
earlier occasion also, none appeared for the petitioner. In that view of the matter, the petition is dismissed. Yes.
May I be pardoned, lords? I am on virtual mode.
Yes, sir.
Can I present next week because I have not seen the brief it has come.
Okay.
Because the petitioner is a lawyer, and one thing I may be permitted to get the LCR in pen drive. Your lordships are allowing that.
Yes, sir. No problem.
And next week any day I will do it.
You are appearing with you.
State pen.
Anybody is there with you, sir?
My associate is there.
And he may come and take the entire record in a pen drive.
Obliged, highly obliged.
Please sit next week. At
Obliged.
the request of Mr. Das, learned senior counsel, please the matter on sunshine. Meanwhile, the instructing counsel of Mr. Das is allowed to collect the inspect the record and inspect the record. Yes. 23.
May I please, Lordship?
Yes.
Only 6 months conviction and 1,000 fine for 326. Offense under section 326.
6 months.
6 months.
126.
326.
320. Let us see the evidence. You have undergone how much?
And
How much? You have, huh? Undergone how much?
Man.
You have already undergone.
Lordship,
Sometime you are on bail throughout.
throughout the
See,
appeal,
let us see the
as well as the appeal, Your Lordship.
Therefore, in view of the reason I hold that the appeal preferred by the applicant is
Running page 21 of the trial court judgment.
Trial court 10 years kathle. Trial court 10 years kathle.
That is 6 months.
Trial court.
6 months and 1,000 rupees fine. 21. Running page 21.
20.
1. I direct the convict to suffer simple imprisonment for 6 months and to pay fine of rupees 1,000.
SI for 30 days.
SI
In default.
Huh?
in default, SI for 30 days. Simple imprisonment for 6 months and
It is
pay.
linked to 294 my lord IPC my lord. Though they charge from 294 and
326.
326.
But he was convicted for offense
On
under
326
326.
6
only.
months. What less can
The
be?
PW my lord, the victim, PW 1.
6 months is supposed to be minimum.
PW 1 is the victim. He told that the accused assaulted her by means of body, causing injury and
Your
damage
Lordship,
on left eye.
earlier
For
Your
that
Lordship
reason,
disposed of
26.
the similar matter.
Both of
A
them.
fine and fine टा देबु conviction टा ये कर 1000 टका जो फाइन टा है हम सेटा दे देगी. So many orders I have also taken from Your Lordship. Nah, ladies.
Let's see when you got the bail. Let us see. Petition will be released on bail. See, you got bail on 6/8/2014. When is the appellate court order?
Appellate court order dismissed the appeal.
Date, tell me date.
Running page 2012.
Tell me the date, sir. Date up to the judgment.
Date of the judgment, Your Lordship, 2/8/2011.
2/8/2011. And but you got the bail on 6/8/2014. Petitioner be released on bail. So when you were taken into custody? 6 months you might have already undergone. Therefore, I'm
326 my lord life imprisonment there by the time must have my lord the course of trial or investigation and also appeal period. Yes,
so therefore, you tell me what
You have
the
to take
custody,
in from
because
the
see,
LCR,
the
madam.
proceeding of this court indicates that on 6/8/2014, the petitioner be released on bail by learned JMC, so and so, on such time and condition. as in
680, Your Lordship, the order passed by this Honorable Court, 680, 2014. Also, the proceeding has been stayed.
I am not on that. You don't understand what I'm saying.
How many
If
days he
the
remained
court
in
has
custody?
released you on bail, that means you were in custody.
I have taken instruction.
You were in custody. What instruction? See the record. You might have already undergone that period.
Yes, Your Lordship.
Why are you unnecessary?
Any instruction take debi na?
What instruction? Read. See the record.
Yes, Your Lordship.
See, these are villagers. They may not be knowing when they went inside jail. You have to be seen on record.
Next week, yes.
No, passing it over 2 o'clock.
Yes, Your Lordship.
You
Yes.
might have already undergone.
Yes, yes. Yes, Your Lordship, 2 o'clock I check the record.
Just see, if the trial court record is there.
Yes.
You come personally see when you were taken into custody.
Obliged.
Because bail is confirmed. That is 6/8/2014. 6 month sentence. You might have completed that
Yes, sir.
sentence. Everything is finished.
Yes.
The fine imposed, I will alter fine and finish it up. Okay, just see, pass it over.
At 2 o'clock.
2 o'clock. Yes.
Item 24, my lord. In item 24, my lord, I am from the OP, my lord, private opposite party and proceeding under 138 NI Act, my lord. In
What is the
previous
amount?
occasion, my lord, petitioner also non-appear for the petitioner. By the order dated 21/6/2024, my lord. I am from the opposite party, my lord. 21/6/24.
Pending since
My lord.
2014.
14, my lord. Non-appear for the petitioner, Mr. Manasan, Lord and Counsel in appearing for the opposite party.
One lakh. Wait. Right now, non-APS for the petitioner, also APS for the opposite party. When the matter was taken up lastly on 21/6/2024, the following order was passed. When following order was today, non-APS for the following order was passed. in view of the fact that the petitioner is not interested to prosecute the matter, as it appears from the record, the petition is dismissed for non-prosecution. Yes. 25.
May I please, my lord?
Yes, sir.
My lords, I have filed a short notes. The lordship kindly see.
This is
My lords, this is
Conviction.
allegations of abatement against the wife of the.
against conviction.
No, my lords. Again, my application for discharge was rejected by the court below. That is why I have filed revision before my lord.
Okay. 109.
My lords.
Yes.
My lords, if your lordship.
1 minute. Everything goes. Accordingly, the petition goes. Yes. Yes.
My lords, kindly see my notes. I have given a short note.
Yes.
Page 2. I have filed the copy of the charge sheet, my lords. In the entire charge sheet.
Who is appearing for this? You are appearing? Ready?
Yes.
Yes.
My lords. I have filed the copy of the charge sheet, my lords. In page 2 of my notes, the entire allegations I am reading in the charge sheet against the alleged petitioner is that his wife, Srimati Kushuma Nair, being a
Was there any stay operating?
No,
my lord,
by the order dated 7th
My lord.
2022, he was allowed to move on an adjournment petition.
Accordingly,
it was continued till that.
Take it.
It was no. My lords, having knowing, my lords, this is the total allegations in the charge sheet. His wife, Srimati Kushuma Nair, being a housewife, having no income, acquired assets in her name, and as such, she abated her husband in accumulation of disproportionate assets in his name, in her name, for which she liable to 109.
Have you put forth separate defense?
My lords, now stage has not come. My lord, why you?
No, but what was, are you an income tax payee?
Yes. Income tax pay, that is additional, my lords. Even that is not there. My lord's judgment, your lordship's judgment. 109 simply saying you have abated, it is not your lordship's judgment kind. Page 4 of that judgment. Page 4, my lords.
Yes.
To prove the offense, my lords, third para, punishable under 109. There are some ingredients to be proved. There, the abater in exercise of his mental process calls the principal accused to commit an offense, and the abater has done it in the following words. My lords, these are the incidents. And in the present case, in the charge sheet, your lordship will not find single allegations of abatement. These conditions, ingredients to be.
But in this case, which you are citing, my judgment, in that case, what had happened is the petitioner in that case is a housewife. He had no income. She said that
Yes,
I have no income. There was no defense on her.
I have seen that, my lords. Your
So
lordship.
therefore, the court says that in the absence of her independent
It will
defense,
go, my lords. I have gone through that.
no abatement can be.
My lords. Here another judgment of this honorable court. Here, my lord, the honorable court has specifically stated that suppose a government servant has possessed a motorcycle in the name of his son. He has given example is given, my
Yes,
lords.
that's right.
That has been set aside. This judgment has been set aside.
That is why, my lords, to
Pratima.
prove
It has
109.
been set aside.
Pratima Behra.
Yes.
Another judgment, D. Das, Justice by Honorable Justice D. Das.
In D. Das case judgment, both the husband and wife are public servants. In that judgment.
My lords, I am not there, my lords. For that, my lords, 109.
Anjali Panda. This is also set aside. Anjali Panda is set aside. By Supreme Court. Anjali Panda has already been set aside.
Set aside, my lords. I am sorry, I have not seen. But my lord's judgment also, 109, there should be some act. My lords, here in this particular case, my
Let us
lord,
go to the allegation, that's all.
yes, my lord.
Let us
There
go
is
to-
no allegations at all, my lord. And my lords, the admitted case of the vigilance is that.
What is the check period?
Check period is, my lords, 2002 to 2000.
No,
2000.
80.
Check period 82 to 2011.
Where is the charge sheet? Let us see.
Pardon me?
Charge sheet. Let us see the
Charge sheet, your lordship.
assets.
3/9/2082 to 12/3/2011.
Yes,
The
I
date
have-
of the search.
I have
And
stated.
3/9/2082 he joined as an engineer. Now in the meantime, assistant engineer.
Yes.
Rural works.
My lords, admitted case is that father of the petitioner has gifted a plot to the petitioner. It is their case, not that I am telling. By selling that plot, there is another plot was purchased by the petitioner. And even
That has to be proved on record.
my lords, what I humbly submit, my lords.
That's what I'm saying. You
Then-
have put forth your defense.
No, no, my
If
lords,
that is your case,
what I-
one of the properties or sale proceeds
My
is
lords, my lords.
factored into the
Double storage
My
building.
lords, assuming for a moment, my lords,
Hmm.
assuming for a moment, she has no income. She has no income, my lords.
Right.
Even some property stands in her name, my lords. When you are charging 109, there should be some evidence, some materials against allegations of 109 to prove 109, my lords. Let my friends show from the entire charge sheet what is the allegations, how they have made out 109, my lords. It is not there.
I would.
And my lords,
120B is also there.
no, 120B, no.
109.
My lords, my submissions in page 3, my lords. There is no clinching material that the petitioner abetted her husband or made any conspiracy or instigated in the alleged accusation of DA by her husband. Nothing. The returns, my lords, she has given income tax returns, but I say I will not accept them. Merely because some of the disproportionate assets stands in the name of the non-public servant without any elements of abatement, they cannot be asked to face the trial along with the public servants on the ground that they are teeth and kin of the.
What is your income in IT return? What?
It is, my lords, 1 lakh like that.
No.
You are into trading of sari.
My lord. And my lords,
Do
the
you have
amount of.
do you have a showroom or from house?
Not
From
tailoring,
house.
tailoring shop.
My lords, and the amount of disproportionate is around 14 lakhs. The the husband of the petitioner has died recently, 4-5 months back.
Main accused.
My lord,
Main accused. He is the main accused.
yes,
Principal accused.
my lord. And now the lady will face the trial for nothing like that. So, had there been any allegations, let them show that there is application of mine, he has instigated. Some allegations to prove 109 must be there. Merely saying that you have abetted not sufficient as per my lord's judgment. 1,60,000, the income per year is. And she filed.
On merit, you don't have a case, but the main point is which you are not arguing, with due respect.
Well,
The main point is, in the absence of the
Main
principal accused,
well,
if you are under the aid of 109, if you are being prosecuted, in the absence of the principal accused, your defense is contingent upon the defense of the main accused. If he is not there, how the prosecution can prove the charges under the 109? That is your argument. This is a technical argument. There are many judgments which will support you to say that in the absence of the principal accused, the abettor cannot be prosecuted.
my lords, when the case was filed.
Oh, you are unnecessarily laboring in these all that. Get that judgment.
Yes, abettor is the main accused. Principal accused.
Principal accused gone. Then
109 happened.
under the aid of 109, how can you prosecute? This is the main point. Get the judgment, you will be acquitted. I'll put it next week. You will get a 109 simpliciter without principal accused, cannot be invoked and prosecuted. This is the only argument you have. If you are laboring on the
No, my
material,
lord's
then
judgment
you are out.
My lord's judgment are very clear.
No, that will not help you, rather you.
In fact, that judgment, my learned friend verified that's a different set of facts, but in the she was absolutely dependent, typical housewife, my lord, claiming no income. But in this case, my lord, the factual aspect which are distinguishable, the she was running a sewing machine on the apparels, this
whatever
stitching shop and all these things. And she said that I've been earning.
But see, the husband was a public servant. He is the principal accused. He dies in the absence of.
That's a different question, my lord.
That is the only question.
Your lordship saddle that responsive to my learned friend, he will come up, my lord. I will also come up with the other judgments.
109. See, because her defense is contingent upon the defense of the principal accused. If the principal accused is not there to lead his defense.
109 can't run alone.
That's the whole thing. Abettor goes. Abettor cannot be.
That is
principal accused goes.
My lords, I agree with the lordship. My learned friend verified the judgments, my lord.
In this case, dies of his own death.
But this proposition has a different facet. Facet
This is
is
only proposition that you
and
get the judgment.
I have told him to.
Mr. Rogada, master is sitting. Master is sitting.
Rijvi also saying that there are.
In fact, that the cleavage of judicial pronouncement, I'll just find out. You just put it out.
These are
The region with the ill-gotten money, my lords, now is in the hands of the so-called 109.
That is a different story.
Anyway, but abatement means abetting to a particular person. I agree with the lordship. That proposition is there. Let him verify. I will also come up with the other judgment. But I agree. There are
direct judgment.
In fact, there is cleavage of judicial opinion also. I'll come back to your lordship.
That this is all proceeds of crime, my lord. That has to be kept in.
Proceeds of crime is something different. You are prosecuting under IPC 109.
Yes. And ultimately, she will face trial, but ultimately she will be acquitted.
Definitely.
Nobody can convict her.
Definitely.
Anyway, it will come back.
He should file a 482 petition and get inquest.
So, but the proceed matter is concerned, that may be the concept of the money launderings. Prevention of money laundering. That's a different question. But it's a Prevention Corruption Act.
I record it and file. You will file a 482 petition.
It can be converted. It can be converted. Your
lordship is giving handles, sir. I will that one. Encash that one.
Everything.
Your lordship is provided.
482 court will cost.
Mr. Bevra, you encash these opportunities. My lord is going to have.
And we get some judgment. We'll see. Okay.
26. 26, what happened, my lord? On the other day, you also engaged Mr. Chinchani.
No, in fact, in this case, my lord, yesterday I got that copy I supplied to my learned friend, my lords.
Yes.
But in fact, Mr. Chinchani, I've gone through that brief, my lords. Mr. Chinchani was engaged as a amicus curiae, as a friend of the court, my lords. And in the copy was served to Mr. Rijvi, but the copy came to me because it was a revision matter.
That I think, my lord, wrongly, my lord, in the order sheet, my lord, order date 24/6 to 24, my lord, You have wrongly, my lord, mentioned the name of the Mr. M.S. Rajvi, my lord, as assistant vigilator. For that reason, my lord, the and also order, order has to be modified, my lord.
I'll modify that, but have you intimated Mr. Chinchani?
Since my
Business phone call. I know him personally. I'll talk to him. After lunch, as you know.
I'll list it tomorrow.
I'll list
I'll list it tomorrow. I'll change this order. I'll list it tomorrow.
Tomorrow. I'll inform.
Wide in order, wide order dated 24/6/2024. Mr. P.C. Chinchani, advocate, has been appointed as amicus curiae in the matter to assist the court. However, inadvertently, on behalf of the state, Mr. M.S. Rajvi, ASG Vigilance, appearance of Mr. M.S. Rajvi, ASG Vigilance has been recorded in place of Mr. Ragada. Accordingly, the order dated 24/6/2024 stood correct. Stood corrected, and in place of Mr. Rajvi, Mr. Ragada APS for this.
Yeah, Lordship may reflect that direct reflection of the Mr. Pratap Chinchani name in the cause
Name
list.
And please intimate tomorrow.
Yeah, yes, today.
Yes.
May it please the Lordship, the petitioner has been convicted under section 323 and sentenced to undergo RA for 6 months and to SI for 6 months and to pay a fine of ₹5,000, and also under section 353 RA for 1 year and 1,000 fine. So
yes.
In the meantime, In the meantime, my lord, he had during the period he had undergone about 2 months.
So substantive sentence is 1 year.
Yes.
1 year.
Yeah.
1 year.
2 months he has already on.
2 months he have already gone. Give me the dates.
The fact is that
item 27.
7. Due to late filing, he was arrested and sent to custody. Thereafter, on trial, during the trial also he was in custody.
Give me in writing. What I'll do is, I will PO remaining part PO.
Yes.
You've already undergone about 2-3 months.
Yes.
Give me the custody period.
Yes.
And what I'll do is I'll convert it to
from the
whatever remaining period PO.
From the LCR, I'll see, my lord.
LCR, give it and in writing.
Yes.
He has already 1 year sentence.
Yes, my lord.
About 2.5 months he has already undergone. And the remaining part he will give.
Late filing, my lord, 2.5 months. Thereafter, during course of trial,
he might have gone on. So the remaining period,
yes,
you will be let off
probation.
The remaining period already undergone. For remaining period, PO.
Judgment reserve.
Judgment reserve.
Yes.
Yes.
29.
Yes, sir.
Amicus curiae
Sorry. Last time I reached late. By that time, matter is adjourned. And today I know that amicus.
Anyway, he is also there. You are also there. No problem. You are ready?
Yes.
He is also ready. When you got ready? You got ready earlier or yesterday?
Today.
Today you got ready. And who has recently get ready? He'll argue. Anyway, somebody should start. No problem. You. Yes, somebody.
6 months and 500 fine.
No, 3 months.
3 months.
Trial court 6 months करते हैं.
Offense?
Offense 448.
457.
No, 448.
448.
448.
Charge framed under section 294, 506, 457. Conviction inflicted under section 448.
Yes.
457 is converted to 448. House trespass. Then first punishment was 6 months.
6 months.
500 rupees fine. In appeal, that was reduced to 3 months only. You have
undergone?
Undergone, I have not. But so far merit is concerned, my lord.
I will leave you on PO.
Yes.
Simple.
Simple.
Conviction maintain PO.
PO.
Please do. PO. And record amicus curiae's name also, his name also. And we will appreciate the assistance rendered by the amicus.
Hello.
Right down. Mr. Janaki Kant Mahapatra was appointed by this court by order dated 19/6/2024 as amicus curiae to assist the court. When the matter is taken up today, you didn't appear since
No, last occasion.
last occasion.
ନା ପୂର୍ବରୁ ତ ଆସିନଥିଲା list.
Yes.
ଗୋଟେ ଏଥର
The
ଆସିଥିଲା।
matter is taken up
ହଁ,
today. Which,
ହଁ।
ମୁଁ
ସେଦିନ ଆସିଲା ବେଳକୁ adjourn ହେଇଯାଇଛି।
along with the amicus curiae and render assistance. This court record appreciation for the effective assistance rendered by the amicus curiae and the counsel for the petitioner. And argument heard, judgment. Yes.
Hello.
30.
No.
Yesterday she engaged as amicus.
Yes, madam.
Petitioner filed this criminal revision against the conforming judgment passed by the learned ad hoc additional sessions judge. Offense under section 47A of Bihar and Orissa Excise Act, sentenced to undergo SI for 6 months, fine of rupees 5,000. Lordship, the prosecution.
Must be same story, only
Lordship,
official witnesses, no independent witness.
No independent
That is
witness,
a regular story.
Constable,
Constable, one SI. And what about the chemical
Seizure liquor
Chemical
was not sent to the.
Chemical
Lordship, decision is there.
chemical analysis report is there on record? No.
No, but I could tell you.
We could tell correct. If the judgment, then we could tell correct. Yes. Then yes. Yes, madam. Which one?
The criminal.
Yes. The judgment, which paragraph?
Paragraph last. Must we prove the liquor to be
Hydrometer and litmus paper test was conducted.
PW.
See, generally what happens, these IO, the inspectors.
IO is
are-
stated that in his examination.
No.
Chemical.
They trained people.
No, my lord, here, my lord, this liquor in question seized by the constable, my lord.
Constables.
And thereafter, he produced the seized articles before the SI of excise,
Right.
along with the seizure list. Accordingly, he made the seizure in presence of witness. Such witness examined PW2. In this case, he denied the knowledge of the seizure.
PW2
Denied. Independent.
PW2 is the
Seizure witness.
independent witness.
My lord. He denied the knowledge.
Okay. What about the
PW3, Lordship, kindly see the PW3, paragraph 2, cross-examination.
No, you have given this judgment.
Judgment
Which
is
paragraph?
Paragraph.
Instead of reading full judgment, I will read to you.
8, Lordship.
8, eh?
Paragraph 8.
8, right. Come on. Yes. Yes, madam.
Lordship. Coming to the present case, the paragraph 8.
Para 8, no doubt.
No doubt.
It is
No
true.
doubt it is true that the means of the illicitly distillating of a liquor is a fact which is gravely injurious to the society, but before the liberty of a man is deprived of on such ground, it is necessary that the offense alleged against him must be established conclusively. It is the paramount duty of the excise personnel to see that the.
That's what I'm asking. Where is the chemical test?
Chemical
Here
test,
not
yes.
done.
Not done at all.
But that has been clarified in page 10, my lord. But paragraph 7. The next submission made on behalf of the accused is that the seized article were not sent for chemical examination, and chemical examination test is the surest test. He also submitted that from the label, and SI of excise could know that it was liquor. In this regard, the reliable decision are reported in 1967 CLT as page 1192. In aforesaid decision, it held that chemical examination is a surest test, but in that case, the accused had taken a plea that he imported a bottle from Andhra Pradesh as medicine. In such a situation, of course, the chemical examination is necessary. So far as this case is concerned, the accused has not taken any such plea, but he has emphatically denied the prosecution allegation in this examination 13 CRPC.
No.
It will not be the.
This is not acceptable. On the level of the bottle, you decide what is there in the content. And generally, what happens is litmus test is done.
It would have hydrometer test. That has not been done in this.
That is not done. That is what this judgment.
And also
says.
chemical.
This judgment
not
says
sent
that
for
in the
chemical
absence
examination.
of that, it has.
And the constable, my lord, he see the he has having no experience.
No. In fact, he lacks the trading and also cannot be considered
Right.
the export opinions.
Yeah, item 20, 27,
30.
30, 30. Item. Acquitted. Acquitted. Right down. By the order dated 26/6/2024, Mrs. Anima Dei, advocate, was appointed as the amicus curiae to assist the court. Mr. Anima Dei argued the matter extensively. Therefore, the court records appreciation of her presence and direct the direction to be issued to whom, Mr. HB, for
Legal
district secretary, district legal sales authority.
Amicus curiae is
No.
I
should direct to whom?
Secretary, district legal service authority.
feet amount लिखी देले से दे दो
The
bill दे दो
the amicus curiae is directed to be paid rupees 7,000 is honorary.
Nice.
Honorary. Directed. I vaguely I write it is accordingly director.
Amicus curiae is
AG, and you raise the judgment. Yes. Thank you very much. Yes.
31 may prefer a passover on behalf of
Passover. 32. How many matters are there? 34. 32.
I please, Your Lordship.
Yes, sir.
Yes, Your Lordship. Revision against conviction, Your Lordship, convicted under section 350, 354 and 377, and accordingly was sentenced to arrive for 2 years, 5 years, and 7 years, Your Lordship. Dear Your Lordship, I have sent message to the petitioner, Your Lordship. I pray for next week because I have to take.
I'll put it in the weekly list.
I'll
put it in the weekly list. Get ready.
My Lord.
Physically handicapped girl.
Weekly list.
My Lord.
Get ready.
My Lord.
Yes.
33.
33 may let it come the first case after lunch.
Passover.
First case after lunch.
Yes.
34.
Sorry.
Yes, 34. This is 34 is Mr. SK Das. Conviction.
My lords, here this is a 2016 appeal, so Mr. Maharana will be appearing.
Appeal, na? This is appeal.
Appeal,
against conviction.
conviction, yes.
Or weekly list of for this. 2016, na?
Mr. Maharana will be appearing in this.
Weekly list.
Yes, my lords.
Then after lunch we'll take it.
My lords.
अभी जो देता है वो है ना फटाफट
Great.
हाँ सतपति बाबू हैं
by the London High Court, that same lords, the state vigilance has brought this leave petition seeking leave of the London Court. The leave was granted, my lords. Now that has been converted to government criminal appeals, my lord.
Right.
My lords, before I delve deep into the matters, my lord, the prohibitory line is, my lords, the scope of interference is only on the factum of perversities. If the findings of the London trial courts are bristling with contradiction or inconsistent with the evidence on records, my lord, resulting in perversity, my lord, that's a point warranting interference of the Sonam Court, my lord. I will not go one line beyond that, my lords. I straightway because in this case, the prosecution case essentially hinges on the trust of the evidence of the decoy, the persons of the complainants, that is PW2, and the shadow witness who accompanies, my lords, PW8, my lords. And I will place that chemical agents report only, then I will sit down, my lords. You'll also turn to page 43 of lordship paper book, my lords. Page 43 contains the statements of the decoy, my lord, PW2, my lord. From that only entire facts will be revealed, my lord. But that will be required for lordship also for dictating the orders, my lords. That's because the entire prosecution case hinges essentially on the trust of the evidence of PW2 at page 43, my lords.
43 of the paper.
Paper book, my lords, but
Yes. Yes.
my lords, let me place it from page 43, my lords. Starting for paragraph 2, did you lordship get that one? On 18/8/92, I had purchased a piece of land in my name and got the sale deed registered in the office of the sub-registrar Jatni. The ticket, the registration receipt was in my name and with the accused Durjodhan Mohanty, clerk in the sub-registrar office. He refused to give me the ticket and advised me to meet the sub-registrar Pradeep Mohanty. The sub-registrar, when I met him, told that I had to give 120 rupees to get the deed and the registration date. When I asked the reason, he clarified that they were charging ₹2 per and 100 rupees consideration as their commission, and as the consideration in my deed was 6,135. Because the registration value was 6,138. I had to pay 120 rupees.
So that is the demand.
That is the crush of the matters.
Yes.
The demands pertain to 120 rupees. Then I replied that I had the money with me, and I told me to come on the next day with the money. Para 3 lots. On 19/8/92, I again made the sub-register in his office. I gave him ₹20, but he refused to accept and told me that I had to pay at least 100 rupees, failing which I couldn't get my deed. He gave me the tickets and told me on payment of ₹100s either to the accused Tola Govinda Patnaik is one of the accused before lordshippers, or Durjodhana Mohan. These are the two accused in the before lordshippers. I could get it from them. Again says after sub-registrar told something in the ear of the accused Dologovinda Patnaik, he gave me the tickets. Tickets are registration slips. When I approached accused Dologovinda Patnaik, he told me that I couldn't get my deed unless I paid 100 rupees, because 20 rupees already paid.
Yes, yes.
The another left out is 100 rupees. As directed by the sub-registrar, on 25/8/92, I approached the DSP Vigilance Bhubaneswar in Vigilance Office Bhubaneswar. He told me to lodge the FIR and come the next day at 8 p.m. Accordingly, I submitted Exhibit 1, evidence the FIR with the DSP and Vigilance. On 26/8/92 at 8 a.m., I came to the Vigilance Office and found, along with the Vigilance staff, including the DSP, outsider, were present there. Lordship, may I kindly skip this paragraph 4. The relevant portion is paragraph next page on to paragraph 5 notes. The real the scenario when the giving and taking of the bribes. Paragraph 5 notes. Then in the vigilance chief, I, along with the vigilance staff, Mr. Babu and the Raut Babu. Lords, you can note this Raut Babu is the accompanying witness with W8 notes. Proceeded to the sub-registrar office, Jatni, and arrived here at about 11:45 p.m. The constable who had tainted the currency notes stayed back. The chief was parked in Ramchandrapur Bazaar, about 150 meters from the sub-registrar office. I followed by Raut, the shadow witness, proceeded to sub-registrar office, and others remained behind. The important line starts here. I met sub-registrar and gave him the tickets. He inquired whether I brought rupees 100. Thank you. And my answer in affirmative. Put his signature in the tickets. The sub-registrar Pradeep Mohanty then directed me to meet the accused Dologovinda Patnaik or Durjodhana Mohanty, both the accused for lordship. Give the tickets. Ticket is the registration slip notes. Give the tickets and money to one of them and get the deed, the registration deed. I gave the tickets to accused Dologovinda Patnaik in dock identified. He inquired whether I had brought money and demanded the same. I gave the tickets and tendered out rupees 100 rupees note to accused Dologovinda Patnaik, which he kept in his chest shirt pocket. Then accused Dologovinda handed over the tickets and tendered notes to accused Durjodhana Mohanty in dock identified. Accused Durjodhana kept the tickets, tendered notes inside the drawer of his table. Now the tented money shifted from one accused to another person.
From Dologovinda to Duryodhana.
Correct, lords. Now, lords, and told me to wait. In the meantime, the vigilance stopped, being instructed by the shadow witness, gave the signals, and the vigilance team rushed to the spot. The DSP asked me about the location of the money, and I told him that the tented money was in the drawer of the table of the accused Dologovinda Mohanty. The vigilance staff then cut both hands of the accused Durjodhana Mohanty and challenged that he had received the bribe from me. Each hand of the accused Durjodhana was washed separately in separate solution, and color of both the washes were pink. As accused Durjodhana told the vigilance staff that he had received the money from accused of the hands of Dologovinda was also washed separately in separate solutions, and color each were so both were put to chemical test, and both hands were found in pink. The pocket of the shirt of the accused Dologovinda in which he had kept the tented money.
That is demand and acceptance, both the proof.
Yes.
But what is the finding?
So far the decoy is concerned, lords. So far decoy is concerned. My lords, may I place just 2 lines more, my lords? I will not go to the details, my lord. Page 46. He had kept the tented notes and was washed, and the color was pink. Mr. Babu brought out the tented money and the tickets which I had given. And lords, must skip all that. These are the, and lords, you can only peruse. I'm not placing one. How much he was cross-exams at length, my lords. When up to page 56, he was cross-exams at length, my lord. But nothing has been elicited to impeach the trust or the evidence of the decoy, the PW on which the entire prosecution case raised, my lords. Nothing has been elicited to discredit this evidence, my lords. With regard to the factum of demand and acceptance, my lords. Now, my lordship, kindly, I will take your lordship to PW8 discharge, whether the factum of corroboration. Let's turn to page 84. Here also I'll place in one paragraph.
84.
Page 84 of lordship notes that contains the PW8 discharge witness statements. But exactly at 85, I'll place only paragraph 2 notes.
He is the Raut Babu.
Raut Babu, my lord. Correct, notes. But he accompanied the decoy notes. Now I'm placing the paragraph 2 at page 85 notes. Thereafter, we proceeded to sub-register office journey and reached there around 11:45 a.m. and we stopped our vehicle near Ramchandrapur Bazaar. And from there, we all proceeded to sub-register office by walk. After our arrival near the sub-register office, Siddhas and myself proceeded to sub-register office and other members waited outside. Siddhas entered inside the room of the sub-register. Das means the decoy members. I waited near the door of that room. And when Siddhas gave the receipt to the sub-register to give the sell deed, the sub-register asked him if he had brought the money. Siddhas told him that he had brought the money. Thereafter, the sub-register signed on the receipt and told Siddhas to give the receipt and 100 rupees to Dolo Govinda Babu. Then also turn to next page. Thereafter, we went to Dolo Govinda Babu and Siddhas gave the receipts and tented money to Dolo Govinda Babu, and Dolo Govinda Babu kept the same in his shirt pocket. After some time, Dolo Govinda Babu handed over the receipt and the tented money to the accused Durjodhan Mohanty, who kept the same in his table drawer. And at that point of time, I gave signal to the vigilance staff, and the DSP and other vigilance staff rushed to the spot.
But he doesn't say that Dolo Govinda has given it to Duryodhan.
Well, so far the factum of demand, acceptance, he fully corroborates. But
recovery has taken place at the from Duryodhan.
Yes, ma'am. That lots may I'm placing a few lines beyond that. Duryodhana, who kept the money in his table drawer. Now, Dolo Govinda Babu and Siddhagal kept the same thing in his shirt pocket. After some time, Dolo Govinda Babu handed over the receipt and tented money to accused Duryodhana. Here the transfer.
Yes.
Here the transfer took place, who kept the same in his table drawer. And at that point of time, I gave signal to the vigilance staff, and DSP and other vigilance staff rushed to the spots. DSP caught hold the hands of Duryodhana Mohanty.
Yes.
But seemingly fully corroborated words. I did not spend more time on that words. And with regard to the chemical reaction, tented both hands were found to be pink.
What is the finding?
And my lords, before I take your finding, lords, we turn to page 94, the chemical agents reports, my lords. That's one also fully supports and corroborates the statements of the decoy and the shadow witness, my lord. Page 94, the last page, my lord. I hope you lordship got it, my lord. Page 94. The last slide, last page of that paper book.
This paper book? 94.
You'll also turn to the last line of that 94, result of examination.
Two, 90?
94, the last page.
Yes, 94.
Let's may skip all they come to the result of the examination. Last slide. The solutions in the bottles marked as A, B, C, D, E, F, G were found to contain philanthropic and sodium carbonates. My lords, these are the chemical reviews which extend solidarity to the statements of the PW two my lords, who is the decoy my lord, who stood the test of cross-examination. Nothing has been dismantled my lords, rather it's strengthened my lords because of the support of PW8, who stood boldly behind PW2 and also the prosecution case my lords. And my lords, I humbly submit, my lord. Now, with the findings of the learned trial court, my lords, your lordship is at page 19 of the paper book, para 7 of the judgments. I think my learned friend will also place that
para
one.
7, yes.
para 7, page 19, my lords.
Here.
My lords, now para 7, my learned friend will place it because case. But so far, the findings are in essence, my submission, my lord, all those findings at para 7, my lords, are contrary to the evidence of record and against the weight of evidence record, particularly the prosecution case solely, my lord, based on the foundation of the decoy statements of PW2, my lords, and fully supported and corroborated by PW8, the shadow witness, and also the another witness, the important witness for prosecution, PW5, the trap laying officers, with regard to recovery factors, my lord. But with regard to the factum of demand and acceptance, these are the two important aspects, my lord. Because if lordship may put me the question that this is what are the charges, my lords? My lord, the charges, my lord, in this case, my lords, is section 13(1)(d) of the PC Act, my lords. Now, my lord, the acceptance of illegal gratification pursuant to a demand by a public servant, my lords, comes well within the ambit of section 13(1)(d). I repeat this one: acceptance of illegal gratification by a public servants in pursuance to a demand. In this case, there was an early demand, on the spot demands. And my lords, there was a transfer of the tented money from one accused to another person's, my lords.
Yes.
And now, my lords, it comes well within the provision of section 13(1)(d), my lord. All the ingredients satisfied. My last submission, my lord. When the demand factum is proved, my lord, on records, my lords, the section 20 comes to our rescue, my lords. Then our section 20 is about the presumption can be drawn. If the factum of demand and acceptance is proved, my lords, section 20 can be resorted to, my lords. That is my second submission. And my lords, before I end, my lords, I'll
what
just...
is the finding?
The finding as
Why acquitted?
paragraph acquitted.
Why?
The reason, my lords, yes, ascribed, I'm placing para 7, page 19, my lords.
Yes.
One place, karibe? Korum, sorry.
Yes.
Para 7 ta korum. Page 19.
So far as the other accused Duryodhana Mahanti is concerned, there is no whisper in the affair that Duryodhana Mahanti demanded 100 rupees from the informant. Though from the evidence, it appears that Duryodhana Mahanti demanded the bribe money, that it is not believable because that fact has not found in the affair. That is the initial statement. So from the preparation, there is no sense that Duryodhana Mahanti demanded 100 rupees. But the money was found from the table drawer of Duryodhana Mahanti. Mere position of the tented money in the drawer of Duryodhana Mahanti cannot be fastened into crime, as Duryodhana Mahanti has neither demanded the bribe money nor he has stated that his statement that money was kept in the drawer. But he has stated that he is completely innocent and not connected with the crime. But the defense counsel submitted that as the informant has inimical term with the sub-register Pradeep Mahanti because he has filed a consumer case against him and lost. He has also implicated Pradeep Mahanti, Dorogovinda Patnaik, and Duryodhana Mahanti in this case. There may be a meeting with the sub-register Pradeep Mahanti or the accused persons, but that cannot prove the innocence of Dorogovinda Patnaik and Pradeep Mahanti, though Pradeep Mahanti is not an accused before this court. So far trap is concerned.
Pradeep Mahanti is not an accused.
Not accused.
Duryodhana and Dorogovinda.
In the statement they say that Pradeep Mahanti demanded.
It is only the Pradeep Mahanti's demand. Yes.
Pradeep Mahanti said that you pay to these two people.
The Pradeep Mahanti you have not made accused. Yes. The demand part basically.
But the earlier demand is there.
The real fact of the case is that, Your Lordship, he presented a document before sub-register Bhubaneswar. Sub-register Bhubaneswar denied to register the document. Reason is that the documents shall be registered at Jottari, not at Bhubaneswar. That is the reason for which the informant lost 552 rupees paper cost. And he filed a consumer case, that is 192 of 2000.
Said evidence nahi tha mu sare
PW2 cross examination, if your Lordship will allow me.
No, come to the finding, let us see. There must be reason.
Happened, Your Lordship. So for trap, page 20. So for trap is concerned, all witnesses, police officers, informant, independent witness have successfully proved have not been broken in cross-examination to prove that the trap was laid and the tainted money was accepted by Gorogovinda Patnaik, and after the money was accepted, his hand was washed in chemical solutions. His wearing shirt was seized, that was also washed in chemical solution. Those articles have been seized in presence of the independent witnesses and have been marked as imbues. The only argument of the learned defense counsel submit that accused Gorogovinda Patnaik did not receive the money for himself, but on behalf of sub-register Pradeep Mahanti, who was his boss in the office, and the subordinate has to obey the direction of his boss. There is no law that a subordinate will oblige his higher officers higher officer in supporting him to corruption. Section 7 of the Prevention of Corruption Act has specifically stated that if any public servant accepts or obtains or agrees to accept or attempt to obtain from any person for himself or for any other persons and gratification whatever other than legal remuneration as a motive or reward for doing the to do any officious act or for showing the forbearing to show in this exercise of his official functions.
Then Dologovinda was convicted for section 7.
Section 7, and his punishment was he stayed in the court for 1 day. In the rising of the court. That is the punishment given to Dologovinda.
What about Duryodhan?
Duryodhan,
not guilty of
21, page 21. They are page 21 therefore in this case accused Dologovinda received the bribe money on behalf of the author, and therefore sorry, page 22 there punishment further submit that our legal punishment cannot be reduced once the accused is found guilty of the offense, but in the particular case, considering the age, period of continuance of trial and broken health, this court feels that the convict be sentenced imprisonment till rising of the court and to pay a fine of ₹5,000 in default, suffer a SI for 3 months. MO1, regarding
what happened in appeal? This is appeal, na? This is
State has come off against an order of acquittal.
So how will you sustain?
Oh, no. Lordship may record my submission that I rely on the statements of PW to the decoy and PW8 minutes. And I also rely. I also rely on judgment of Supreme Court. Lordship may record my submission. It says that the demand of money by first accused and acceptance bribe by the second accused at the behest of the first accused proves by evidence of
Pradeep Mahanti is not accused.
No, that's Lordship correct.
Then this judgment will not help you.
Yeah, your Lordship may turn to page 43, my lord, who demands emanates from whom, my lords?
Emanates from Pradeep Mahanti.
Your Lordship may turn to page 44, para 3. I'm placing 1 line. 44, Choralis.
Of the judgment?
No, that paper books.
Paper. Yes.
Page 44. I'm just placing the fact, Your Lordship. Page 44, paragraph 3. On 19/8/92, did Your Lordship get it? I again made the sub-register in his office. I gave him ₹20, but he refused to accept and told me that I have to pay at least ₹100, failing which I could not get the deed. He gave me the tickets and told me to the payments of ₹100 either to the accused I could get the tip. Again says that after sub-register told something, the accused Dologovinda gave me the tickets. When I approached accused Dologovinda Patnaik and told me that I could not get my deeds unless I demand color. When I approached accused Dologovinda Patnaik, he told me that I could not get my deed unless I paid 100 rupees as directed by the sub-register or
Directed by.
So this was also a co-demand, I mean, a joint demands.
What was his age that time?
The decoys.
You have filed 2 appeal or 1 appeal?
No, we have filed this, in fact, one leave petition.
You are challenging the acquittal of Duryodhan or acquittal of Dolagovinda for offense under section 13?
No, in fact, this leave petition was filed, my lord, incorporating both the opposite parties. Both because the cause title indicates that both the parties are there.
And this judgment, which paragraph?
Which paragraph the judgment totally? Naveen Bhai judgment.
Yeah, this is only lots with regard to that the demand by one accused person and acceptance of paragraph.
But if you not make accused, how would you?
Yes.
Lordship, I record my submission. That's
Judgment trigger. Heard me to soon. Heard. Yes.
Item 12.
Yes. Well, what is this matter? On APS. Conviction, against conviction.
Private party. Copy is not stop.
These are not safe. The present petition is arising out of a complaint under section 138 NIS. The petitioner was convicted by the court below. Therefore, he has challenged the conviction, judgment of conviction and order of sentence passed against him for alleged offense under alleged offense under section 138 NIS. The petitioner, nobody appears for the petitioner. In the last date of hearing, also nobody appeared for the petitioner. Therefore, on 19/6/2024, the following order was passed. Today, when the matter was called for the second time in the afternoon, nobody appeared for the petitioner. In view thereof, it appears the petitioner is not attached to proceed with the matter according to the same is discussed. Yes.
Item 15.
No, weekly. Yes.
Item 23.
Yes, sir.
6 months. 6 months. The site for 6 months and 1,005. In the meantime, the appellant petitioner arrested were 22/2/2003 and the released on bail 15/3/2003. Thereafter order 22/2/2003.
Arrest
22/2/2003.
Arrest
22/2/2003
22/2/2003
and released on bail 15/3/2003.
15/3/2003. Bas.
Thereafter, after the
Conviction.
Conviction. And thereafter appeal filed by the.
Yes.
petitioner during the course of appeal, the NBW after
Yes, yes. Tell me when you were taken into custody.
15/7/2014.
15/7.
On the Sunday,
2014. Bail.
Bail on 14/8/2014.
14/8/2014 କେତେ ମାସ ହେଲା ଦେଖନ୍ତୁ ଫାଷ୍ଟ କେତେ ହେଲା ଫାଷ୍ଟ ଫେବୃଆରୀ 22 ଫେବୃଆରୀ ମାର୍ଚ୍ଚ ଇଟ୍ ଇଜ अबाउट 1 month ठीक है 8 ଗୋଟେ ପ୍ରାୟ 15 ରୁ 15 month 2 months you have already undergone out of 6 months.
Yes.
This is the period undergone and the remaining period 2 months he has already gone out of 6 months.
6 months, but in fact, my lord,
Okay.
fine amount to 1,000, my lord, imposed. But in fact, what happened in this case, my lord, the
I am maintaining conviction.
My lord.
PO. Conviction maintained. PO. Petitioner has already undergone about 2 months. लिख लो, हाँ? 2 months. It has roughly. Yes.
31.
All the best. All the best for you.
Respecting your lawsuits, that matter where 7 years conviction, 5,000 rupees fine for the
Yes.
force on the
376. Yes.
The trial court judgment was confirmed by the appellate court, thus the division is filed. But it is the specific case of the
Mr. Raghuda, ready?
Madam.
but that he was done. He was done. But it is not revealed from record that any test was conducted in order to know the authenticity of such complex. Nothing has been done. Only basing on the statement made by the mother or informant that has been done. The lordship, on scanning the evidence, my lord.
He is simply dumb or deaf and dumb?
Not deaf and dumb.
Only dumb.
Only dumb. That is also not possible. Generally, if a person is dumb, he is deaf. That is
Yes.
lordship, they, according to the prosecution, she has given birth to a dead child. But PW11, the doctor, who examined her, what is her statement? I am just pressing.
If she is dumb, how she has given the statement?
That is one part, my lord. She has given statement.
Yes, yes.
But Pedal 2, my lord, that is judgment. Pedal 2, victim has stated.
If your case is the prosecutor is dumb, how the statements are recorded?
First, he has given the evidence, my lord.
Is there any
But Pedal 2.
sign language interpreter was there?
That is not there, but in fact, my lord, the 6 paragraph 6, my lord,
of
the trial court judgment.
Yes, yes.
Pedal 2, the victim has stated in her evidence that the
Trial court,
accused-
Trial
my lord.
court. 1 minute.
My lord, cut.
Trial court is
Page 29.
it's realistic, maybe 1 minute, 1 minute.
Paragraph 6.
Yes. 6, yes.
The Pedal 2 victim has stated in her evidence that the accused called her to his house when there was nobody in his house. Accused gave her chocolate and assured to keep her in his house. He also assured to purchase bangles, sari and sindoor for her. Thereafter, accused made her lie on the ground and slept over her. After opening her sari, accused also opened his lungi. This witness has further stated that as she slept with the accused, it intimated by my mother. So, she was pregnant by the time the accused committed sexual intercourse with her.
Submission within a week. Prison. With supporting judgment, yes. Yes.
Just that.
Last one matter was a lordship fixed it at 2, a criminal appeal, a vigilance matter. Your Lordship. So
Which
that-
one?
33, your Lordship had problem and fixed it at 2 p.m.
Yes.
34.
Okay.
Your Lordship has heard 3 matters. If your Lordship
3 matters.
already your Lordship has reserved 3 matters. If your Lordship
I mean, every day 5-6 matters. These are very different.
that is the reason. If your Lordship is, then we can this at least give a brief pursuit. Otherwise, your Lordship will fix it.
No, today it's not possible because I have a special bench. Special bench, yes. And let it be included in the weekly list. This is the vigilance appeal, huh?
Vigilance appeal.
Next week, they can ask Mr. Das when, because there are other matters also listed for hearing. He has to also get ready.
I'll catch it him asking to get ready. in
For your Lordship, it will take only half an hour. This matter. Only
Half an hour is a big matter.
Only trap case, 5 witnesses.
Okay.
No others. Over hearing, magistrate, complainant, DLO, IO. All. For your Lordship, it will take half an hour.
But a little bit of
Contradictions.
little.
So next Friday, let it be taken up.
Then what you are suggesting is the conviction is correct. Little bit of contradiction, then it can be ignored.
Technically, the other aspects may be met, but there's a little bit of twist in that. So they did not meet.
Okay. We'll see.
Yeah.
Next Friday, let it be taken up.
Any day convenient on your office.
Mr. Sahu, in one matter, you were appointed as amicus curiae. The petitioner counsel came and appeared on the other day. You said that, okay, he is doing it. Subsequently, when the matter came up, again he evaporated. So I told them that to intimate so that you get ready that matter. Thank you very much.